Hi, Attorney Kip from Malek. In this video, I'm going to be talking about like a commission order. This is an order that it was a DHO and then went to SHO, and then somebody appealed it to the full commission at the Industrial Commission. So it's heard by the three commissioners. I think this decision was published in February of this year of 2022. Um, but if you watch the prior video where I talked about I think it was August 8th or 10th of 2022, the recent decision from this AutoZone case. Um, Similar fact pattern. In that case, the guy got injured and then he ended up getting terminated, and then there was a period of time where he's off, then he got approved surgery through his claim, and then the magistrate in that 10th district case had said, hey, he's entitled to comp under 412356F, and he didn't care about what reasons the guy was terminated for. He's unable to work because of the work injury, because he had surgery to fix issues through the workers' comp claim. This commission order is similar fact pattern. So the deal with this one is this guy had an injury in 2016. He ended up having surgery in 2017 in his back. And then he ended up doing vocational rehabilitation, which is basically job training, in 2018. And then he returned to work pursuant to that job training in the field of light delivery, dispatch, or retail. And I guess he got a job as a driver. So in 2019, September 2019, in this job as a driver, he had a motor vehicle accident, and he was terminated from that job on September 16th, 2019. What's interesting is I think those dates are very similar. I think it was a year later in that other case, but be that as it may. So he continued, and then he was involved again. Returned to work, had this motor vehicle accident September 13th, 2019, and then he was terminated from the job on September 16th, 2019. And then in the hearing or in this commission order, they said there's no evidence the injured worker received further physical injury as a result of that motor vehicle accidents. And then they go on. This is the important detail. There is no indication that the injured worker has worked or looked for work within his claim-related restrictions since he was terminated on. Since he had the injury on September 13th, 2019. So he has this thing. He didn't return to work, but um, he has, through the claim, he gets referred to see a orthopedic surgeon, Dr. DeGenova, on July 9th, 2020, and then he eventually has surgery on December 15th of 2021. And it looks like he had a procedure at the L3, L4 level. It was a spinal fusion, and I presume they don't really say it in this thing, because in that mandamus case, that 10th district case, they explicitly say, hey, that guy had shoulder surgery. It was paid, or was approved, or paid through the claim. This they're just saying, hey, this guy had a procedure at L3-4 level with a spinal fusion. Now, you could maybe infer that it was paid through the claim, because this guy's claim was allowed for, he had substantial aggravation of pre-existing disc disease at L3-4, and he had post-laminectomy syndrome at L3-4, and he had left L3-4 intravertebral disc displacement. So I'm assuming, since he's seen DeGenova and he's having surgery, I'm assuming it's paid through the claim. So DeGenova, he certified him. Certification, and basically this guy requested comp following that surgery. So from 12/15/2021, and it looks like in this case he had requested surgery from 7/9/2020. So that's a little bit different from that appeals case, because in that case, remember, he was requesting comp from the date of surgery to continue. This one, it looks like he's requesting comp from July 9th, 2020 to continue, I presume. They don't have an end date. Yeah, so it's 7/9/2020 to the present. So, and this was, again, February 2022. So 7/9/2020 to February of 2022. So if we would have looked at this from the magistrate's case, the magistrate, under that case, very similar facts. That guy he had a work injury, he was terminated, and then he got surgery, and then the magistrate said, hey, I don't care about why he was terminated or whatever, but the reason why he's not working out is because he had the surgery allowed in the claim. This case, assuming that he had the surgery in the claim, I would assume the magistrate would also do the similar thing. He would say from the date of the surgery, 12/15 of 2021, to continue, he's entitled to comp. And the reason why is because he's not working, because he's having surgery on his back, which is allowed in the claim. But in this case, it's a little bit different because he's asking from 7/9/2020. But be that as it may, the court or the commission said, hey, remember 412356F is two statements. And there's the first statement, which goes for the claimant, and there's a second statement. If an employee is not working or has suffered a wage loss as a direct result of reasons unrelated to the allowed injury or occupational disease, the employee is not eligible to receive compensation under the section. And then so they say, under these facts, on this situation, he was not working as a direct result of reasons unrelated to the injury and conditions allowed in the claim, and the request for payment of temporary total disability is denied. So in this instance, they took a different decision from what the magistrate said, and they said, hey, we are concerned about the fact that he was terminated. And if you remember, there was that line that they put in, and this is really important. There is no indication that the injured worker has worked or looked for work within his claims related restrictions since his re-injury of September 13th, 2019. So that's so basically they're imputing, if you want to look at it as like a flow chart, this guy had this intervening injury, he was terminated, he had surgery, and there's a request for comp. So between the termination and the surgery, the commission is basically saying that guy either had to have returned to work somewhere, or he had to have shown that he tried or attempted to return to work somewhere. And in this instance, he didn't. And since he didn't, he's not entitled to comp. That's kind of an onerous thing. That's actually not in the statute. That requirement is not in 412356F anywhere in there. And they're reading that in. The commission they're actually taking these elements of voluntary abandonment, and they're putting this job requirement back into the statute. They're reading into the statute, and they're creating law that doesn't exist. And the problem is this is what happens when you throw everything in the works with this 412356F, and you throw out the voluntary abandonment. That all that case law got erased, but now they're creating new law, and what might happen is this might go up to be appealed to the 10th district, and that then might be appealed to the Supreme Court, and then that might be law. And so the law might in fact be, oh, you have to show that you're trying to work or you have worked. And in fact, they have another case I'm going to talk about. I think it's Taku, but I'll call it the Taco case because it's more fun. But when we talk about that guy made extraordinary efforts to try to return to work. And because of those extraordinary efforts, similar situation as this, they said, oh, he's entitled to comp, but is that the requirement? That's kind of scary, if you ask me. Particularly if somebody has a back injury and it requires fusions, how are they going to be able to work anyways? Maybe they're going to be under extreme pain. Maybe the only work they could possibly do would be sitting in a chair making really boring YouTube videos for people to watch. Maybe that would be the only thing. But a lot of folks are laborers and stuff. So if they have a physical injury like that, they can't work, and even if they tried, they wouldn't be able to, because they wouldn't be able to physically do it. So it's like they're putting this onerous requirement on people in some of these decisions. But again, as we saw in the recent 10th district case, the magistrate said, not a requirement. We're not putting, he didn't have that anywhere in his decision. So we'll see how this plays out. You got to be aware of that. 412356F is not great. And so you got to be cognizant of these things. Bottom line, if you have a factual situation like this and you're not represented, you're committing a crime against yourself, essentially. But if you have, as I say in all these videos, this stuff is too complicated, there's too many little pitfalls that you can get involved in. wrong roads that you go on, wrong paths that you go down. So if you have a workers' comp injury, it's going to pay you dividends to get a workers' comp attorney involved. And so I highly recommend you can either reach out to us or do like a Google search and look for a workers' comp attorney. Ask your friends for references, but call up a workers' comp attorney. Ask them if you need to get an attorney involved in your situation. They might say, yeah, you need to. This is what we recommend you do. We'll represent you. Otherwise, you need to get an attorney involved. So if you get anything out of this, take that out of this video. Otherwise, if you have questions, concerns, comments, you could email me. You could leave them comments in the comments section. You could call our office and we'll see if we can help you out. So you've been listening to Attorney Kip at Malek and Malek. Thanks for watching this video. Stay safe. Don't get in a work injury, but if you got a work injury, give somebody a call, okay?